Hey everybody, this is Jason McGrath, and this is another segment of Carolina Contracts. We're talking about arbitration in this series of video blogs. And with this part of it, I'm going to talk about whether you're going to go ahead and identify the body, the organization that's going to host the arbitration, or what rules are going to be used. So what you often will see is that an arbitration provision will say something to the effect that the rules of the AAA shall apply, and that's the American Arbitration Association. But a lot of times you'll see arbitration clauses that don't contain that. And so you can be stuck in a situation where it says, we're going to arbitrate, but there's not really any guidance there, or more importantly, any agreement between the parties that's already set in stone, so to speak, as to what entity is going to be used, what rules are going to be used, et cetera, et cetera. So you can waste valuable time and money arguing about that. On the other hand, you don't want to be overly specific. I'm aware of a situation where there was a contractual clause by one of the largest companies in the world, quite frankly, that deals with consumers and lending and credit and things like that. And they actually had an agreement with all of their consumers that said you have to use this particular arbitration association. And it wasn't the one that I just named. And what ended up happening was a federal court looked at the overall situation and said, you know what? This arbitration group is finding on behalf of this large organization in something like 99% of the cases. And it's clear that that is not correct and equitable. And we are now forbidding this arbitration organization from handling arbitrations for this massive corporation. Well, they ended up in a bind because they had all these agreements that said we will arbitrate in front of this organization. And now they were legally prohibited from actually doing that. So it caused just a big old mess for them. Probably deserved on their part, quite frankly, but nevertheless, it was unfortunate for them. So be careful not to be too specific. You may want to not name an organization necessarily, but you may want to go ahead and name the set of rules. For example, the AAA has some streamlined rules that are often used for business cases, and I've used them. But what you might want to do is say, you know, this is what we're going to do unless the parties agree otherwise. So you don't bind yourself completely, allow some flexibility, but provide some framework for who the organization is going to be that you use, or at least what rules are going to be used, so you don't waste valuable time and money, you know, fighting about those logistical things, but rather can just move forward and try and get the substantive issues resolved.